Welcome everyone to the webinar, Beyond Title 42, Further Restrictions on the Right to Asylum in the U.S. Thank you for joining. My name is Kevin Appleby. I'm the Interim Director of the Center for Migration Studies of New York. Today, we're going to talk about the proposed rule by the Biden administration published in the Federal Register on February 23rd that would deny asylum to certain non-citizens who neither avail themselves of lawful and safe pathways to the U.S. nor seek asylum or other protection in a country through which they travel. The rule creates a rebuttable presumption of ineligibility for any asylum seeker who fails to meet these requirements. The rule is expected to go in effect on May 11th, when the administration will lift the COVID-19 public health emergency and the use of Title 42. We have three experts today with us to talk about the humanitarian, political, and legal consequences of this proposed rule and the best methods for opposing it and defeating it. They are in the order of which they are going to speak. First, Eleanor Acer, Senior Director for Refugee Protection at Human Rights First. Eleanor oversees Human Rights First pro bono representation program and advocacy on issues relating to refugee protection, asylum, and migrants' rights. Gelernt is the Deputy Director of the ACLU's Immigrant Rights Project and Director of the project's Access to the Courts program. Lee has argued dozens of civil rights and immigration right cases at all levels of the federal court system and was the chief litigator in opposing the Trump administration's Title 42 policy. Finally, Dylan Corbett is the Executive Director of the Hope Border Institute in El Paso, Texas, an immigrant advocacy and service organization which brings the perspective of Catholic social teaching to bear on the realities unique to the US-Mexico border. Dylan also is the regional representative for Mexico, Central America, and the Caribbean for the Holy See's Migrant and Refugee Office. We welcome our speakers today. Once they have given their presentations, we will have a question and answer session. Please use the Q&A button to submit your questions, and please identify yourself and your organization. So now I will call on Eleanor to begin. Thank you, Eleanor.
Thanks so much, Kevin. And thank you all for joining us here today to hear about this horrific policy. The Biden administration's proposed rule would ban many refugees from seeking asylum in the United States and deprive impacted refugees of the ability to reunite with their families and pursue a path to citizenship. Members of Congress, human rights advocates, faith-based groups, and many others have previously voiced strong opposition to this plan and urged the administration to not take the step that it took last week. The proposed rule would make refugees ineligible for asylum based on manner of entry into the United States and transit through a third country, subject to some highly limited exceptions, which I can talk about in a few minutes. The Biden administration's proposed asylum ban would be a combination of a third country transit ban and an entry ban, a new iteration of similar bans implemented by the Trump administration. It also attempts to impose new restrictions on the ability of people to seek asylum at ports of entry, codify a nationality-based approach to access to asylum via parole initiatives, and push people to seek asylum in countries that do not meet the US law requirements for safe third countries. And it attempts to make access to asylum for refugees at the southwest border, and only there at the southwest border, contingent on use of the CBP-1 app, a notoriously flawed and often inaccessible, routinely oversubscribed smartphone app. While the proposed ban is framed as temporary, right, any period of implementation would result in the illegal return of refugees to harm, and the trajectory of the Title 42 policy, as we've all witnessed, makes it very likely that this policy will continue to be used and abused, potentially by future administrations as well, unless it is abandoned or stopped. In his February 2021 executive order, President Biden had promised to restore and strengthen our asylum system, which has been badly damaged by policies enacted over the last 4 years. As a candidate, he pledged that his administration would not deny asylum to people fleeing persecution and violence and would end restrictions on asylum for those who transited through other countries to reach safety. The proposed rule flies in the face of these promises. The administration plans to impose this asylum ban on May 11th, 2023, when the illegal Title 42 policy is currently slated to end. But the last thing that the Biden administration should be doing is advancing the agenda of the former Trump administration and its anti-immigrant and hate group allies by replacing one inhumane Trump-initiated policy with another policy straight from the Trump playbook. Anti-immigrant hate groups and allies of the prior administration have actually welcomed the Biden asylum ban proposal. The Biden administration's pursuit of this asylum ban is a tremendous humanitarian, legal, and political mistake. So what will be some of the consequences for people seeking asylum? Human Rights First closely monitored the impacts of the Trump administration's asylum transit ban and issued a comprehensive report on it back in 2020. If implemented, the proposed asylum ban will inflict grave harms on Black, Brown, and Indigenous asylum seekers, as well as LGBTQ+ asylum seekers. While the Trump asylum transit ban was in effect, immigration court asylum denial rates skyrocketed, as did credible fear denial rates for many Black, Brown, and Indigenous asylum seekers requesting safety at the southwest border. Those barred from asylum due to the Trump transit ban and ordered deported to danger included Indigenous asylum seekers fleeing gender-based and other persecution in Guatemala, a Congolese woman who'd been beaten by police in her country, a gay Honduran asylum seeker who was threatened and assaulted due to his sexual orientation, and a Venezuelan opposition journalist and her one-year-old child. The policy also resulted in family separation. For people denied asylum due to the ban and left only with the deficient protection of withholding of removal, those individuals under the current ban in situations where let's say one parent came here to the US to seek asylum, they would be deprived, even if granted withholding of removal. So even if recognized as refugees, they'd be deprived of the ability to bring to safety their spouse and children in the United States, leaving the family permanently separated. In addition, that refugee would be denied a path to citizenship. Plus, like the Trump transit ban, this new transit ban is going to be applied in the expedited removal process, a due process deficient process to begin with. Like the Trump transit ban, we would expect to see dramatic decreases in the grant rate for credible fear. In addition, reports have indicated that the Biden administration plans to apply the new transit ban and it plans to conduct expedited removal in CBP custody. That is, in essence, a resurrection of the flawed Trump-era Acer and HARP programs, which the Biden administration rightly ended. Let's talk for just a minute about some of these exceptions. So the exceptions that are included are highly limited. For example, if an individual arrives at a port of entry, they will be subjected to the ban. The presumption can be overcome only for exceptionally compelling circumstances, like an acute medical emergency, imminent and extreme threat to life or safety, which is in the language that precedes the rule, described as something highly limited. And also, there's an exception very similar to the one in the Trump ban for victims of severe forms of trafficking. Now, the inclusion of exceptions does not in any way make these provisions legal. It doesn't turn what's illegal into illegal because there are exceptions included. In addition, there's an exception for unaccompanied children, which people should be aware of. The rule will apply, as I mentioned, in expedited removal and also in the situation of actual hearings for those who are not subjected to expedited removal or those who are not actually expeditedly removed. Finally, I want to talk in my remaining, what's left of my 5 minutes, which I fear I have exceeded, about the path forward. Okay. The Biden administration should really withdraw this proposed rule and do so immediately, and take steps to advance real solutions, as many NGOs have urged the administration to do. To start with, to uphold refugee law at ports of entry and along the border, to restore and maximize access to asylum at ports of entry without imposing restrictions, bans, and limits on access to asylum on people who do not or cannot schedule advance appointments via CBP-1. Many of you probably know from your own experience or from what you've read how flawed the CBP-1 app is. Our laws do not require people to actually make an appointment in order to seek asylum. But that's in essence what this rule is trying to do. In addition, the administration should focus on further strengthening capacities to receive and protect refugees in other countries, but not requiring them to do so. And to expand and strengthen refugee resettlement and other regular pathways to the United States. To upgrade and properly staff asylum processing, to fairly and swiftly decide cases and address backlogs, rather than imposing unworkable counterproductive timelines and bans that lead to mistaken decisions, inefficiencies, and lengthier adjudications. Finally, to stand up to racist, anti-immigrant fear-mongering, rather than adopting xenophobic rhetoric and versions of policies that the prior administration pushed. I'm happy to answer any questions, and apologies that I couldn't cover everything related to the rule in my 5 minutes.
Thank you, Eleanor, for that. Very helpful. Now we'll turn to Lee Gelernt for his statement. Thank you.
Thanks,
Lee.
Kevin. Thanks for having me. So I just want to cover a little bit of what happened under the Trump administration and a little bit of what we're going to do with this new rule legally if it gets enacted. So this rule is a little bit of a hybrid of the first two asylum bans that the Trump administration enacted. The first asylum ban barred asylum for people who entered between ports of entry, colloquial terms, entered illegally. And we challenged that with our partners, and it was struck down by the Ninth Circuit Court of Appeals. And the reason it was struck down is because Congress has very explicitly stated that you must have access to asylum, whether or not, that's from the language of the statute, 8 U.S.C. 1158, whether or not you entered at a port of entry. And the reason is sort of very practical and is consistent with international law that not everyone can get to a port of entry. Some don't know where a port of entry is. Sometimes cartels push them across the border at particular places. They could be with a young child, and the port of entry could be hundreds of miles away. Sometimes they're fleeing and need to just get across wherever they can. So both international law and our domestic law has very clearly stated that you have access to asylum, quote unquote, whether or not you entered at a port of entry. And so the reason, and again, that was struck down by the U.S. Court of Appeals in the Ninth Circuit on the ground that the transit ban, the rule that the Trump administration enacted, was inconsistent with the laws Congress enacted. And I bring that up because this Biden administration rule, proposed rule, has an aspect of that in that it disfavors people entering between ports. And that aspect, we believe, would be vulnerable for the same reason, in that Congress has made a decision that it doesn't matter how you enter the United States, you must have access to asylum. The second asylum ban that the Trump administration enacted was the so-called transit ban, and that obviously is analogous to parts of this rule. It said you must apply for asylum in a third country first, and if you're denied, only then can you apply for asylum in the U.S. That was also struck down by the U.S. Court of Appeals, the Ninth Circuit, unanimously. And that was also, there were a few of the judges had different rationales, but the core rationale there was that it was, again, inconsistent with the laws Congress has enacted about asylum, which says that if you enter you transit through a third country, you can only be denied asylum if we have a formal agreement with that country, and there's a full, fair, and functioning asylum system in those countries. And we do not have, so that goes to obviously the proposed rule here, that you would need a formal rule, and you would also, on top of that, need to make sure that whoever we have a formal rule with has a fair, functioning asylum system. And it's one thing when you say, well, we're going to have something with Canada. It's a whole other thing with some of the countries that people would transit through Latin America. We showed, for example, that Guatemala only has a handful of asylum officers. Mexico does not have what we would consider a full and fair functioning asylum system. Plus, we don't have a formal agreement. And so we think the Biden administration's proposed rule is absolutely unlawful. And just to echo one point that Eleanor made, we welcome additional legal pathways to apply for asylum. Obviously, no one's against that, but they cannot be a substitute for the basic right, the basic mechanism for applying for asylum, which is you escape danger, you get to US territory, you arrive at the US, you have to be allowed to apply for asylum. If there are additional ways, that's great, but it cannot be a substitute for the basic form of asylum. And so I know that the Biden administration is striving very hard to say, well, look, our rule is very different than the Trump administration's. And I think that's for the obvious reason that the Trump administration rules were struck down. But the fact that they have added some additional pathways, we don't believe should matter legally. The fact that you can overcome some of the problems with presumptions, again, doesn't matter, because those are just additional obstacles on top of what Congress has enacted. So the basic core legal problem with these rules is that they're inconsistent with what Congress has enacted. We think there may be other problems with it, but that's the basic core rule. And so I'll stop there, Kevin, and happy to answer questions, obviously.
Thank you, Lee, for that. Finally, we'll have Dylan Corbett to talk to us about the realities on the border.
Thanks, Kevin. Can you hear me?
Sure can.
Good. Okay, good morning, everybody. Coming to Dylan Corbett here, coming to you from El Paso, Texas, with the Hope Border Institute. We work here in El Paso, which is on the border with our sister city, Ciudad Juarez, where we also work. Since the Trump administration's implementation of Remain in Mexico, we've operated a humanitarian program in Ciudad Juarez, and we work with a lot of the people who we expect to be impacted by this new policy. And to be quite frank, just to preface some of the things that I'm going to say today, more than 2 years into this administration, things look a lot like they did under the previous administration in Ciudad Juarez, with expulsions, summary expulsions, and people having to wait and circumvent, which is what is increasingly becoming a more complicated system of protection, because those are the political options that we've made as a country. Let me start by just making a few observations on the policy, which are going to echo some of the things that Eleanor and Lee have said. And I'm grateful to be on the webinar with them, my colleagues. There's really a kind of a perverse logic to this, because what we're seeing now is that the administration, we've talked a long time about the need for a regional approach to migration, and to the need to respond to asylum seekers and all vulnerable migrants in the region. What the administration is really doing is putting in place their own regional system of protection, and it's a diminished system of protection, and it should really alarm all of us. And this is but one element of that. Remember, the CBP-1, for example, was meant to be an exception. They're going to lean a lot on CBP-1 in order to make this happen. In Spanish, there's the expression "dorar la píldora." Every time they announce a really bad policy, they try to pair it with something good. So in October, when they expanded the Title 42 to Venezuelans, and then later to other populations in the region. They expanded some of the parole options. That was good, but it was really bad when they made Title 42 basically mandatory for those populations. CBP1, as Lee said, it could be something in the toolbox. It could be a way of people accessing, but it shouldn't be the only thing that we lean on. And it's problematic, as Eleanor said. There are a lot of problems right now, and I'll speak to that a little bit. But they're dorando la píldora. They're dulcificando una mala noticia. They're trying to sweeten the pill with some really bad things. And now it's this transit ban. So they've taken some of the logic from Title 42, the ability to expel people rapidly. And now they're going to do that perhaps with Title 8 and these expedited removals programs. So they're taking the lessons from Title 42, and they're taking even some of the lessons from Remain in Mexico. You can make people wait in Mexico as they access through CBP1 this really difficult entryway into the asylum. And now this asylum transit ban, it's going to increase the burden on Mexico, just like these other programs have. It's going to increase the burden on other countries that are already dealing with some really tough issues of displacement on themselves due to violence and instability in the region. We can expect an increase in exploitation by migrants, by traffickers. We can expect an increase in migrant deaths. Remember, we've had an exception process in place under Title 42. That's what CBP kind of, was born in that context. It was meant to be an exception window under Title 42. Well, at the same time that we've had that exception window, migrant deaths have skyrocketed. And so we can expect that trend to continue based on the data. Whenever you restrict legal pathways at the border, you always have situations of trafficking and deaths go up. And so those are to be expected. The administration, as I said, has created some parole options for a limited number of countries in Latin America. But the odd thing is that those are good in themselves. We need more of those options, those legal pathways, but they're not connected to asylum. So they're not connected to the most vulnerable who are going to be affected by a policy like this, who need to move and often need to cross borders rapidly. Lee spoke to that. There's a presumption somehow that the cases of those who access parole, or the situations of those who access parole, and the cases of those who access the asylum system through CBP1 are somehow more meritorious than those of asylum seekers who apply in between ports. And that's just specious, and we think it's illegal. The administration has also not expanded some of those parole options to the countries where a lot of people who are seeking asylum are coming from, like Northern Central American countries. And that's problematic because there's been a long-standing pattern over the decades of discriminatory policies towards that region. A policy that leads to adverse outcomes because of national origin for those in need of asylum. I mean, that's fundamentally regressive and unacceptable. Remember, this was always the dream of the Trump administration, to be able to stop people from accessing asylum between the ports. And now we're embracing it under this administration. Today is March 1st. It's the birthday, if you remember, of the Department of Homeland Security. And since we created the Department of Homeland Security back in 2003, so that's 20 years, the 20th birthday, we still don't have the capacity to process people at ports of entry. Think about that. We've spent probably $333 billion on immigration enforcement in the 20 years that DHS has been around, and we still don't have the capacity to process asylum seekers. We want to funnel them through the ports. We don't have the capacity to do it. CBP1 is effectively going to become a metering system, a rationing system, and that too is unacceptable. And the fact that we don't have that capacity, again, it's a political option. It's an option we've made as a country. So at the end of the day, this approach, while it has the appearance of sort of being piecemeal and they're rolling out things in an ad hoc manner, it's all part of a plan to reduce protection in the region. It's all part of, it has its own architecture, the agreements with other countries, the expedited removals, the deportations, the hardening of the border. This is the same logic that we've seen under the previous administration, but really for years and decades. And it's going to require political courage to upset that dynamic. The metric at this point is still how many people we keep out, not how many people we're able to protect. And that's not right. That's, again, a political choice. You know, the predicate, even if you look at the policy, it's written, it's right there, you can read it in the policy. The predicate is that there's an emergency and that we need to run roughshod over the rights of asylum seekers and vulnerable migrants in order to address this emergency. Another example of the emergency becoming the norm. This is what happens over and over and over at the border. They posit a post-Title 42 emergency that requires we do this. You know, so they admit it right there. What we need to do is harden the border. That's what this is, fundamentally a strategy to harden the border. And it's going to disproportionately impact vulnerable migrants. It's just another chipping away at the rights of asylum seekers, part of this broader trajectory. Briefly, let me speak about a couple of the things that we're seeing on the ground. They're going to lean heavily on CBP1. We've been, you know, CBP1 is in place right now under Title 42 at the border. So we have a sort of dress rehearsal for what we're going to see. You know, capacity is an issue in Ciudad Juarez. People are waiting. They're being forced to wait, you know, to try to access the system because, as Eleanor said, it's oversubscribed. There are equity issues. You've heard about people with darker skin, people who are indigenous, not being able to access or having problems accessing the system. That's happening here on the border. You've heard about language problems. You know, it's not available in a variety of languages still. They're working on that, but there's still issues with that. And because it's oversubscribed, it also pushes people to try to seek access at other ports. And that's really dangerous. And for a lot of people, they don't have the ability to travel to other ports of entry because they don't have, not everybody has the legal ability to do that in Mexico. One of the things that we've done, you know, with the announcement of the expansion of Title 42 and the parole options is we also sweeten the pill. You know, we're leaning on Mexico to do increased enforcement at the border. That's happening here in Juarez and other parts of Mexico. And so when you push people to other parts of the border, there's an increased chance that they're going to be intercepted. And Mexico they have increased their enforcement at the border. And so asylum seekers who are forced because of the logic of CBP1 to apply at other ports of entry and travel long distances, they're going to encounter that enforcement. And people here in Ciudad Juarez are being picked up and in other parts of Mexico. And that's a problem. It puts people at risk of being removed. I've talked about the deaths. I've talked about how we're basically outsourcing this issue to northern Mexico with all the attendant problems on that. The lack of social services, the lack of shelter, the vulnerability, the exploitation, the crime. Again, this is fundamentally about a lack of courage. You know, the administration is embracing some of the logic of the previous administration. We could do something different. It's fundamentally a political and a moral question. You know, we have asylum seekers who are coming to the border. We have significant operational control of the border. What do you do when the stranger comes to the border and knocks at your door? What do you do? The previous administration implemented these policies because they put their finger on this question, and they chose to demonize the other. They chose to politicize this in a really dangerous way. And it's troubling that the administration is embracing some of that same logic. We need a humane response. This is not just a political question, it's a fundamentally a moral question. We need to welcome the stranger. We can do this. We've been doing it at the border for years and decades, despite all the challenges. It's possible to do it with humanity. It's possible to do it with compassion. It's just a question of political will and courage. Thank you.
Thank you, Dylan, and thank you to all our speakers. We have about 20, 25 minutes for questions. I know Lee has to leave a little early, but hopefully we'll get in most of the questions before he has to leave. Let me just start with the panelists with a question while we wait for other questions. Generally, what are the ways that people can get involved in this fight in terms of advocacy, in terms of making comments to the rule, for example? What are the wide range of options that they have to oppose this rule? To anyone?
I can jump in on that. So, I mean, the first thing I don't know if we mentioned that there's only a 30-day comment period here, which is really, given the scope and impact of this rule is inexcusable and likely inconsistent with law. But there are many ways for people to get involved. So Human Rights First, along, I'm sure, with many of the groups here, are working with American Immigration Council, which has spearheaded an effort to allow and facilitate the ability of individual people to file comments. And we really encourage people to do so, focused on their own experiences with the asylum system, to really write comments that are their own, but really encourage you to do so. And then the other thing that you can do is talk to your members of Congress. That's so important, that members of Congress be hearing from their constituencies, that the White House be hearing from people who are concerned about this rule. Those of you who are involved in the Welcome with Dignity campaign, there's already been one protest and there may very well be others. And there are some of you on this line that are from organizations. I really encourage you, despite the short timeline, to file comments to describe the impact on asylum seekers of the prior ban and how you believe asylum seekers will be impacted by the current one, and the ways in which you think this ban is illegal if you do. Thank you.
Okay, thank you, Eleanor. So we have a question from Kristen Maher from the San Diego State University. The question is, I suspect that if asylum seekers are denied asylum in another country, that would be the basis for a court here to deny them as well. Do we have evidence that immigration judges may consider other countries' judgments as a basis to deny? Have you seen that in the past, or?
That's a great question. I'm not familiar. I don't know if Eleanor or Lee have any information on that.
Yeah, I mean, I think it's sort of a bit of a trick thing, right? If you've been denied in another country, right? Obviously there are arguments you can make for why that decision was improper, or why you should actually be granted asylum in the US. But it essentially is a rule that is really aiming at preventing anyone who arrives at the southern border, other than a Mexican national, from being able to apply for asylum, unless they've used CBP-1 or meet the other, very limited circumstances.
And I think we can envision, in Europe, for example, once an asylum decision is made, the asylum, it's sort of there are common standards, so it's accepted across the European Union. But in our context, because we don't have those agreements regionally, you could have a situation where people are literally pushed around, because of some of these dynamics. I anticipate that we'll have situations like that. People who will be pushed from country to country to country.
Eleanor, we have a question for you. You mentioned that it is from Nadia Ryman. She doesn't give her organization, but for Eleanor, you mentioned that the way the new asylum restrictions are written sets the ground for them to persevere beyond the Biden administration. Can you say a little bit more about that?
Yeah, so the rule says that it's slated for 24 months, I believe, temporary, right? There's also a reference in there that seems to indicate the Biden administration might move ahead even more quickly with implementation. But what I said was that the trajectory of the Title 42 policy, right, raises concern that despite the 24-month period specified in the rule, that we could very well see this policy continue in the future. And that's, both the politics of Title 42 and the interests of immigration authorities, once they have any kind of authority, in ever letting it go, despite its downsides.
Thank you, Eleanor. There was also a question from Carl Bergquist about the timing for the rule. They could have had a normal 60-day comment period, but instead waited and had to rush it for the May 11th date. And I know you already addressed that, Eleanor, but there was concern about that. So another question, the DHS fact sheet says that the proposed rule proposes that if one family member is accepted from or rebuts the presumption, all family members will be similarly treated. The question is, does this apply to withholding of removal? And does the family member have to be present with them?
Yeah, our concern is that I guess I don't even want to call it exception, but that provision, seems to be applying only to families who arrive together. And what we saw again and again and again with the last transit ban was asylum seekers who would come here, not in many cases not bring their spouse and child on the very difficult journey, and then not be able to reunite with their families. In many cases, families may be in hiding in home countries, but could not be brought here to safety, leaving the family permanently separated.
Great, thank you. We have another question from Anna Cabot. What is the timeline for filing the suits described to challenge this rule? I don't know if that's a formal thing or not. Can we talk about that? Or
yeah, so I can't get into too much detail about the timing. I just, as a starting point, I would say that if the rule is enacted in the form it's been proposed, we will challenge it in court. The same reasons we challenge Trump administrations. The timing is up in the air. I can't say too much about it. And I think, we're gonna give it a little time to see what happens. But I would say that the administration has also left open the possibility that they will issue what's called an interim final rule, an IFR. If that happens and it takes effect immediately, I think that will alter our timeline and we will go in and challenge that IFR. If they're not going to do that and it's going to be a proposed final rule, then I think we're going to have to figure out the exact timing. That's all I can really say at this point. I'm sorry.
thanks, Lee. We have a question from Abel Nunez of Kerrison, DC. How does this policy connect to the changing demographics of the US? And is that an underlying reason how we can address it? I know, Dylan, you had mentioned something about the regional strategy. Is there any connection there?
How does it connect to the changing demographics? Yeah, I'm not sure if this gets at the question, but again, I think at this point, after all the damaging policies that we witnessed under the previous administration, I think there was broad hope that we were going to redress some of those wrongs and begin to put in place a safe, effective, humanitarian, humane, and compassionate, frankly, system at the border that would guarantee the rights of asylum seekers and vulnerable migrants. And what we saw, under the previous administration is that they were smart to the changing reality at the border, the increased number of asylum seekers, not numbers that are not manageable in terms of the overall number of people arriving, but an increase in the number of people seeking asylum. And we know why they're seeking asylum. It's obvious if you look at the region right now, what's happening in Cuba, what's happening in Venezuela, the social and political crisis there, in the ongoing, deep challenges in Northern Central America, the situation in Nicaragua, all exacerbated, of course, by the pandemic, by countries that were not able to, that didn't have the same resilience and tools available to respond to the pandemic that we did. You know, we know why people are coming. And, you know, the fact too that again, we've got significant operational control of the border now. So the moral question is sort of spotlighted. And the previous administration chose to demonize. The previous administration chose to whip up fears based on, you know, a lot of fears that people have about changing demographics in the United States, and chose, you know, the logic of xenophobia, and which made it all the more necessary for the new administration to really, you know, choose a different path. And again, these are all elements of that same logic. You know, the logic that we've embraced at the border, you know, oftentimes people think that we have a sophisticated strategy at the border. We really don't. We let some people in, we keep a lot of people out. And it's a really blunt system for deciding, you know, who comes in and who can't. And over time, the logic is, you know, really the only through line is that we are increasing, you know, militarization. We are hardening our border, and we are criminalizing, you know, looking at people who are coming to the border as if they're criminals, to include now asylum seekers. And so we're sort of casting the pall of criminality over more and more people. That's the logic. And in many ways, it's a logic of pain that we're applying at the border. We make it painful for people who are coming to the border, and it's the vulnerable that pay the price. And one administration will turn that dial of pain up, and one administration might turn it down a little bit. But fundamentally, unless we change direction, it's that same dial of pain. And unless we frankly address that, you know, we could go back to, you know, a situation where, you know, this will be politicized again, and we'll respond with more xenophobic politics. That's why, you know, Eleanor said, it's really hard to believe that this isn't going to be politicized in 2 years, and that this exception doesn't somehow become streamlined, mainstreamed, because we haven't dealt with these issues as a country. And it comes down to a question of political leadership. You know, these are half measures that we're seeing that don't really get at the issue. And so in that sense, yeah, you know, there are broader dynamics in the country around changing demographics that I think play into this.
Thank you, Dylan. We have a question from Katrina Burgess of Tufts University, I believe. Excellent remarks. I have a question for Lee. What are the odds that this rule will be overturned by the courts?
Yeah, thanks for the question. You know, as a general, I never try and predict whether we're going to win or not. I would say that we do think the law and the facts are on our side. We do not think that there are any legally significant differences between this proposed rule and what was struck down under the Trump administration. Having said that, you know, we'll have to see and how hard the government pushes it. Do they take it all the way to the Supreme Court? You know, so I know that's not a satisfying answer, but I do think that the law is on our side, and we do not think that the administration's relatively cosmetic changes alter the legal calculus.
Thanks, Lee. We had a question about how it applies to unaccompanied children, but Eleanor, you mentioned that. I think that there's an exception there.
Yeah, and there rightly is. I mean, but the rule shouldn't be applied to anyone. You know, another family separation concern I'd add is one that we've witnessed again and again with policies that deny, you know, access to asylum to refugees fleeing harm, is that what ends up happening is parents have to make the impossible choice of, do they send their child to safety across the border on their own, right? Or keep them with them in circumstances that are highly dangerous and where the children are facing, very grave risks. So yeah, I would just say that's yet another family separation concern relating to this proposed ban.
And locally, to speak to that point, one of the issues, hopefully these are bugs that are not features, but it's really difficult for families to use CBP1. And so, we've been hearing reports of families having to make that choice, where children cross the border are received as unaccompanied minors, because people are having these issues with CBP1, and families and larger families are having a lot of challenges accessing the system.
Okay, we have a question from Hillary Dick. Thank you for everyone for that detailed, clear, and powerful overview of the proposed rule. It sounds like this rule, like many of Trump's attempts, oversteps U.S. statutes. Can someone clarify what section of the U.S. Code covers the parameters for administrations when they create new rules? That might be something we need to get back to you on.
Well, I think just generally, it's you ought to look at 8 USC section 1158 lays out the asylum rules.
Thanks. There was a question about how do we comment on the rule. I think it's pretty clear in the proposed rule how to do that. That's correct, Eleanor.
Yeah, and I tried to drop in response to some of those questions, a link to the AIC, Welcome with Dignity campaign that allows individuals to actually file comments on their own. So for people who are just thinking about doing it on their own, that's a really easy way to file your comment. But organizations definitely encourage you to do that on your own. And if people are not seeing that, let me know. I've been trying to figure out if there's any other way to send that information out broadly to everyone, but hopefully someone who's more tech savvy than me can make sure that that's been sent. There it goes. Great, perfect.
A follow-up is it recommended only the directly impact, such as asylum seekers or organizations that work with asylum seekers submit comment? Is it also recommended allies, advocates also submit public comment? I will venture the guess that the more the merrier, but Eleanor, is there a specific strategy there?
Yeah, I mean, I think this is an important opportunity for the administration to hear from people. So, as I said earlier, it's important to be really specific about why you're concerned about this policy, what you would like to see, and why you think it's inconsistent with law or good policy. So I would encourage, specificity and your own words.
Okay, we've got a more challenging question from Ted Pinton from the Jesuit Conference. He says, as you've all presented very well, there are very strong arguments, both moral and legal, against the new rule. That said, I wonder if calling it an asylum ban or transit ban doesn't overstate the case in a misleading way. It's not quite a ban. Does anyone want to respond to that?
I'm happy to answer it, and then I don't know if Lee has any, anything more, or Dylan does on it, but like the Trump bans, it renders people who are actually refugees, people who meet the eligibility requirements under U.S. asylum law, right? It renders them ineligible for asylum. Yes, there's presumptions that maybe some can overcome. Some may be spared, but others will not. And so I think it is actually pretty accurate, very accurate to call it, a ban. We're not calling it a transit ban or an entry ban. We're calling it an asylum ban because it's both a combination really of a transit and entry ban in some ways. But definitely there are some exceptions in there. We think they're going to be very difficult for people to prove. But at the end of the day, many people who are refugees and eligible for asylum are going to be banned under our laws or not even have a chance to apply for asylum.
Okay, we have a question from Zita Oroka. This is probably one for you, Dylan. Can you discuss why this piecemeal approach at asylum at the border instead of an overhaul of the immigration system? What has the percentage been on enforcement versus other forms of immigration, legal, work-based, family unification? You mentioned 333 billion over 20 years.
I'm sorry, Kevin, could you clarify the question? There were a couple elements there, so I get confused.
Well, you already answered it probably, Dylan, in your statement, but they want to sort of you to tease out more why you think there's a piecemeal approach to asylum instead of the overhaul of the whole immigration system, both the legal immigration system and legalization. What is your view on that? And then they ask, you know, they want a comparison of what's been spent on enforcement versus other aspects of our immigration system. But you also mentioned that as well. So I think they just want a further comment on that.
Yeah, I mean, one of the dynamics I think that's you know, taking place here at the border is that there's always been a Faustian bargain. When we talk about, you know, the questioner made reference to, you know, a broader reform. When we talk about things like comprehensive immigration reform, there's long been a Faustian bargain, you know, that we need increased enforcement, that we need a crackdown here at the border, that we need policies that would disproportionately impact people who are seeking asylum. That's always been the case. You know, if you look at the last couple of attempts at immigration reform, you run into that dynamic. And it's a false choice, you know, that, you know, we can decouple immigration enforcement, you know, enforcement of our borders from the broader questions of immigration. But as a country, we tend to, because of politics, we tend to yoke those two things together and box ourselves into that Faustian bargain. And we need to always be attentive to that. We always need to push back on that logic. You know, that's a false logic. Those are false choices that our politics boxes us into. But what happens because of that logic that's so, you know, that's so strong, is that whether you ever get, you know, whether we ever get to reform or not, we always get increased enforcement here at the border, constantly. So the numbers, you know, in terms of the budgets, for example, for Border Patrol, CBP, you know, the logic of what I called militarization always deepens. So, you know, even when we don't get immigration reform, you know, we get an increase in appropriations for you know, agents at the border, Border Patrol agents, for you know, technology, for wall building. You know, it's sort of, even if you look at, for example, the budgets, you know, that the administration has put forward, they're increased appropriations for enforcement. And that's enforcement here at the border, as well as ICE enforcement in the interior. It's really hard to arrest that dynamic. So even in the absence of reform, we've gotten the sort of the short end of the stick of that Faustian bargain. And it's something we have to push against. I don't think people realized how militarized our border is, or how now that we're having this question where we're casting the pall of criminality over asylum seekers, which are a protected class. You know, Ellen, I mean, look at how we're buying into the logic even in this conversation. Eleanor talked about, you know, had to reinforce, this is, I understand people's concerns about how we talk about the asylum transit ban, because there are exceptions, but this is a ban. And for legitimate bona fide asylum seekers, just because they don't use this technology, which they may not have access to, and just because they pass, they cross in between ports of entry, which is completely legal, we're going to accept that the threshold is going to go higher than the standard for an ordinary asylum seeker, than a credible fear interview. That standard is now higher. We're erecting further hurdles. You know, we're buying in some sense to that logic. So we've always got to be attentive to that, because that political logic is so embedded in how we address the questions at the border. We got to fight against those false Faustian bargains that we make for ourselves.
Thanks, Dylan. So we have just a couple minutes. Two quick questions. When does the rule take effect? That would be May 11th. And when is the 30 days over? I believe that's March 27th, if I'm not mistaken. So with the last 2 minutes, I just wanted to ask the panel if they had any final words for the webinar that they wanted to say. Please go ahead if you do.
Lee, you want to go first?
Yeah, sure. I would just echo what Dylan and Eleanor have said, that it's really important to speak out. I think there's a feeling in the administration that for most people, the border is out of sight, out of mind, and that no one really cares, and there's going to be no political price to pay for it. I think people just really need to show that they care and that they recognize what's going on and that they understand there's a human dimension to this and an historical dimension, that we said after World War II we would never send people back to danger. We're now going on our 3rd year of no asylum in the United States, which should be a really shocking thing to people. But unfortunately, I think we've lost a little bit of the narrative, and the human dimension of this and the importance of asylum is getting lost in abstract policy arguments and aggregate statistics and snapshots of people crossing the border. So I would encourage people to really speak out. It does matter.
Yeah, and I would just quickly flag, I saw some of the questions on international human rights obligations. Clearly this, this ban would violate a number of U.S. commitments and legal obligations under the Refugee Convention, including prohibitions against return to persecution, prohibitions against penalizing asylum seekers, and the right to seek asylum itself. I want to just flag for 1 second in closing the broader concern we have about the administration's use of rhetoric as well as policies intended to inflict harm on asylum seekers, intended to punish them for seeking asylum, whether it's framed as quote unquote consequences or the dehumanizing references to carrot and stick used against asylum seekers, and linking safe pathways to denials of access to asylum too. These are all approaches that undermine refugee protection here at home, hurt asylum seekers, and subvert refugee protection globally in ways that are just not in the US interest anyway, as well as being just wrong.
And you've got the final word.
Yeah, just echo what's been said by Eleanor and Lee, and encourage people to take advantage of this comment period opportunity. That's important. Encourage people to reach out to their lawmakers. There's I think 80 members of Congress who have pushed back on this. We need to increase that number and continue to push. And what we're seeing is, again, it's hard sometimes to know what you had before you lose it. And what we're seeing is really the slow boil of the frog. That's what this is. And we need to oppose it, and we need to push back. We've got, the different one thing that's different now that I think maybe is different with respect to maybe at the beginning of the Trump administration. We've got good solid research and advocacy strategies. You look at this webinar, you see it, you see Lee from the ACLU, you've got the legal strategy and the litigation, you got that pillar, you've got the research, you've got the advocacy with Eleanor. We've got hospitality efforts at the border. But what we need on these issues fundamentally is going to be public action. It's got to be the public pushing back. There's got to be a response to push this administration to do the right thing and to change course.
I want to thank all the speakers for giving their time today. Really appreciate your comments and insight. You can go on their websites. I don't have their sites, but their organizations: Human Rights First, Hope Border Institute, and American Civil Liberties Union. And I'm sure there's more information there as well. And thank you. And our website, of course, is cmsny.org, where you can find information as well. So thank you so much for everyone being on, and have a great day.
Thank you. Thanks, Kevin.
Thank you.